Hi, everybody. That's a weird sound. I'm not used to being in the rotunda. So cool. Thanks for having me. I'm Matt Deliberato. Can everybody hear okay? Good. Excellent. Well, welcome. I am an estate planning and elder law attorney. What does that mean? Elder law, I don't think anybody thinks of themselves as an elder. So I don't like the term elder law, but we deal with a lot of issues that do deal with anything from probate and trust administration to creating and protecting assets. These are the things we're going to learn about. Today is about education. Today is me just giving you as much as I know about estate planning to hopefully help you make a better decision. In your handouts today, I like to go over an agenda. If you're watching on recorded, you don't have handouts, but don't worry, it doesn't matter. But in your material, you do have some information about us, some information about the topics we're going to discuss, and you also have in there an evaluation. I make 3 promises every time I present. And that is, the time together will go fast. So for the next 3.5 hours, oh, I'm glad you laughed. Thank you. No, we're probably going to be about 45 minutes and then questions, answers. You know, people always say, I've got a dumb question. I said, don't worry, I have a dumb answer. So don't be afraid to ask it. There is no such thing as a dumb question. We're going to go through a little bit about our background, identify what you want to know, discover the 3 steps to plan and protect your estate, and then close and help you create that action plan. A little bit about us. Thanks to Michelle, who's here with me today, has finally changed the picture of my kids, because my kids kept saying, Dad, would you change that picture? We don't look anything like that anymore. They grow so fast, don't they? Think about where you were 5 years ago. And where will you be in 5 years from now? And how fast did that 5 years go, right? Time is just moving. It's just a matter of what we're going to do with that time. And don't forget, we call this proactive estate planning because we want you to do something. Reactive, doing nothing, leads to problems. And I can tell you all my problem stories, but I'm not going to bore you with those. But it's all about family. You're not sitting here because of you or watching this because of you. You're here because of your family. When we talk about estate planning, it's what happens when I'm gone. What happens to my stuff? And I just call it stuff because no matter how valuable it is, you can't take it with you, right? It's just stuff. So let's talk about that together. Oh, first of all, I'd like to tell you a little bit about why I do what I do. And it begins with this couple. Anthony and Alice, they were married a long time ago, and probably, in fact, in an era where 4 out of 5 doctors recommended smoking for your health, right? I mean, it's just craziness how things have changed. Oh, by the way, I'm sorry, those 3 promises, I forgot to finish those. Not only will the time go fast, you'll learn something, and we'll have some fun. And as long as I keep those 3 promises, if you would just fill out that evaluation if you're in-house, that would be great. Anyway, at age 65, Alice passed away. And a huge part of Tony died with her. In fact, he stopped wanting to do things. He stopped wanting to go out. He didn't want to go to meals. He didn't want to get out of bed. So he moved to assisted living, which I believe he had 8 more years of his life that he wouldn't have had. Why? Because he started developing relationships. In fact, he'd come over for dinner and say, I got to get back there. They've got beer tonight. Just fun stuff. The month he died is the month he qualified for Medicaid and spent every penny he worked for his entire life. These are my grandparents. This is why I do what I do, because I know there's a better way. The better way is being proactive and planning, and that's what we're going to talk about today. Most people want to know. When I start talking, I used to say, okay, tell me what you want to talk about. And this is the answer I would get. Dead silence. Thanks, you did it again. You proved me right. That no one really wants to volunteer, so I'm volunteering for you. The first one is, can I protect my stuff from government, long-term care costs, family? Family? Yeah. And how do we do that? It's the number one question I'm asked. I've worked hard all my life. How do I protect my stuff? What is a trust? What's the difference between a revocable and an irrevocable trust? Everybody's heard about trusts. We just don't know what they are and what they do, and we're going to cover that. How can I avoid probate, or do I need to? Right? Not everyone needs to avoid probate. And that might sound counterintuitive because most people I talk to say, I don't know what probate is, but I know I don't want to go through it. But we're going to talk about why. Can or should I give my stuff to the kids or others, the house, accounts? The answer is no. Besides your spouse, you should not have your kids on your accounts, on your house. And when I say that, everybody looks at me like, what? I've got my daughter on my account. What are you talking about? Well, by the time we're done here today, you'll understand what can happen and why it's not a great idea anymore. It used to work, right? Remember the old days? I argue the old days are right now. We're creating them, but the old days, it worked. We just give the house to the kids and put it in their name and everything was fine. Well, we'll talk about why that doesn't necessarily work anymore. If I give my stuff away, will it take 5 years for it to be safe? Everybody's heard there's a 5-year look back to Medicaid, and we're going to talk about what that means and how it applies to you. What is a power of attorney, a living will, a healthcare proxy? In New York, they call it a proxy. It's a healthcare power of attorney. Sometimes I'll use the word proxy just so we don't confuse the power of attorney for financial with the power of attorney for healthcare. What's the difference? Which one do I need? How can I plan for my disabled beneficiaries? Does anyone have disabled beneficiaries? Interesting. So the question, okay, so we do have one, but the question is, for the rest of you, how do you know? See, I call it the 2-finger test. You take 2 fingers and you place it right here on your wrist. You feel that, the thumb. You're alive. Cannot someone become disabled during your lifetime? And so we're going to address these issues as well. Are my IRAs safe? Do I need special planning for them? And finally, how can I avoid estate taxes? Usually this is a pretty good list, but if there's anything else you want me to talk about, please tell me, and or forever hold your peace, right? No, we're going to take questions at the end, and so you're welcome to ask. If it's okay, just jot them down. That's why we provided a pen, just so we keep the flow, because usually when you ask a question, it's the next slide is the answer, because you're really getting it and you're following along. So great. The goals today. The goals are just to identify if your current plan meets your goals. You know, if I took a poll, and I won't, but how many of you have something in place now, whether it be a will, a trust, whatever, or nothing? The question is it going to do what you want it to do? There was a study done of 94 out of 100 people. Their plan wasn't going to do what it was intended to do. So it's time to look at this. Then we want to understand what it takes to protect you and your stuff. And again, don't think about this as a class. This is just having fun to me. And in the process of having fun, we'll learn something. And then we'll show you how to get what's missing. There's really 3 steps to plan and protect your estate. You have to know the rules, you have to know the options, know your predators and know your options. I'm getting ahead of myself there. First of all, we have to know the rules. See, the government has rules for us, right? We call them laws, and a lot of you in this room probably deal with some laws. And those laws tell us that if we're alive, we can create a power of attorney. What is a power of attorney? It's a legal document that allows someone to create or handle your legal and financial affairs if you're unable to, right? Healthcare power of attorney, living will, these go hand in hand, and they deal with end-of-life issues, right? If I can't make a decision for my own health, who's going to make that decision? And I'll be honest with you, these 2 documents become so very important. Why? Well, think about it. Let's say I have a stroke, I can't sign a check, I can't sign my taxes, I can't sell my home, I can't, whatever I need to do, I need someone in place to do that. So when we talk about basic estate planning, I start with during life, not actually when you pass. So, believe it or not, the state of Ohio has created forms for these. They're an option, they're downloadable, they're at no cost to you. I would argue that it's not tailored to you, and so we'll talk about what that means and why you'd want to do something different than what the state has already provided for us. What if you don't have these? You have to go through a legal guardianship. Has anybody been through one of those? A guardianship is what I call an RPIA, a royal pain in the you fill in the blank, right? Because it is court involvement. It is knock, knock, knock. Hi, Mr. Deliberato. I'm here from probate court to determine whether you're competent or not. How are you? How am I? That's the worst question I could get asked. But again, I wasn't proactive, I was reactive, so maybe I have to go through a guardianship. It's not fun. And I think even the probate court would admit that it's time consuming, right? It has its ways, and there are ways to avoid it. How about after we're gone? See, we can create a last will and testament. That says who's in control, that's the executor, and who gets the stuff is called the beneficiaries. But at death requires probate, which is a government process. And I'm not here to bash it at all, but I will tell you why people don't want to go through it. Number one is, it takes 7 to 9 months to go through. That seems like a long time, but that's actually the minimum. It could be much longer. It's public record. Elvis, Prince, Michael Jackson, James Gandolfini, anybody know that name? From The Sopranos? Yeah, they all died without wills. Can you imagine all that wealth and nothing, no plan, nothing? I can tell you how much went in their estate and how much came out of their estate. Most people don't want their assets to be public. And last but not least is the cost. Now the cost, it's not probate court. To open an estate is $350. That's beautiful. Who charges all the money? The attorneys. We have to get you through the process. And so the court sets a fee for that. And that's where people say, probate costs a lot of money. It does, because we have to get you through the process. That's all. I hope at some point, or at this point, you've learned one thing. Something I've said is new. However, I think we've gotten to the biggest distinction we're going to get to all day, and that's the difference between plans and documents. See, we believe planning works, documents don't. I know all of you have seen, you can go online, you can create whatever you want, from a will to a trust to a power of attorney, whatever. Those to me are documents. Without a plan, and we're going to see throughout this whole day of what plans mean versus documents. By the way, I forgot to say when we were talking about wills, all wills go through probate. I don't want that to be a misconception, because I have people say, oh, I'm not worried about probate, I have a will. No. Probate works on how you own things. So for example, I have a joint account with my wife. I die, it goes to my wife. Any probate? No. I have an account with beneficiaries on it. I die, goes to the beneficiaries, no probate. I pass away with something in my name only, where does it go? Probate, thank you. Probate, of course. So, I'm sorry, I skipped that part. So I'm going to come back to documents versus planning, because first of all, what did I say a power of attorney was? A legal document that allows someone to control your legal and financial affairs. And I think there's inherently a problem with a lot of power of attorneys that I see, in that it's a blank check. If I give you a blank check, what can you take from me? Everybody always says everything. Well, it's a trick question. It's whatever's in my checking account. But what if I give you power of attorney? What can you take from me? Everything. You say, well, that's not what I wanted. I understand, but it's different from doing a document versus plans. Because a plan will include full authority with instructions. Maybe a better way to explain that is a healthcare power of attorney. A healthcare power of attorney, why do you think we call it a God power? Think about that. A healthcare power of attorney is a God power. Well, we really get to decide whether or not someone lives or dies. That's playing God. And you know, people love to make that decision. Yeah, no. My example is a couple married 57 years, they go to dinner and the wife has a stroke, and what happens? Everybody picks up one of these. They dial 911, in come the paramedics, they give her CPR, they give her oxygen, they give her breathing treatments, right? All these things to get her back to 100%. Funny thing is, she had one of these documents that says she doesn't want any of that, but it's an emergency, right? That's what they're there to do. 3 months go by and they say, well, I'm sorry, you're gonna have to make a decision. Your wife is not responding to the treatment. And what does he say? 57 years of marriage, that's plenty. Go ahead, pull the plug. No, he doesn't say that. Of course he doesn't say that. He's thinking, oh my gosh, the love of my life, this woman who I've been with 50, well, maybe 60 some years, right? Before we were married, and I don't want to lose her, and I got to call the kids, and you feel all that anxiety. But instead, what we have is a second crack at the apple in our power of attorneys, which says, I want everything. But if in 30 days, and you select the days, and believe me, the days don't matter, but if in 30 days I'm not showing signs of getting better, then I don't want it anymore. Did you hear the difference? Not you make the decision, right? It's I don't want it. That's a huge change in power of attorney law, and something we have to look at. Remember, a last will and testament does go through probate, so it is a document to me. It's not really a plan. Number 2 is knowing your predators. You know, I'm speaking to the city of Cleveland employees, and I'm saying the government's a predator. I don't mean it's a predator. They're not after you, right? But it's something you can avoid. And so therefore, are these things that we can avoid? Absolutely. Do you think your family's a threat to your financial security? Oh, you betcha. So I know I say predatory, but listen, it's not predatory. But it is guardianship, probate. These are things that happen if you don't do anything. By the way, for all of you worth $13.9 million, please raise your hand. Oh, I don't see a hand. You're in my boat. Oh, we got one. I have a good plan for you. No, we're not in that boat. Right now, $13.9 million, you don't pay federal inheritance tax. Isn't that awesome? Next year, it's probably going to go down between 6 and 7 million. However, long-term care costs are probably one of the biggest things we need to worry about. It used to be, I could tell you, our average stay in a nursing home was 1.5 years, and now it's more like, it can be 5, it can be 8, right? We can't figure this thing out, and so we're getting dementia, Alzheimer's, and these things are leading to longer terms of being in. The question is, how will you pay for the care? And we'll talk about that in part 3. Unanticipated or unintentional predators, this is probably one of my favorite topics, because this is what has changed in estate planning over the years. Think about it. It used to be, here's your will, here's your power of attorney, thank you, have a great day, all set. Today we have to ask other questions. Like, for example, let's say I pass away, my wife remarries, she dies, he gets all the money, he dies, his kids get all the money, my kids get nothing. That happens all the time. All the time. I can't tell you how many stories I hear where this happens. Not intentionally, right? Don't forget this is all unintentional or unanticipated, but remember that we want, better story yet, my wife never remarries. In fact, she loved me so much she erected a 20-foot statue to me in the backyard. Yeah, right. But she then needed long-term care. It's not what we anticipated. It's not what we expect, right? These are things we have to consider. Children, beneficiaries, ooh. You know those angels, they always get along They never argue. Money's never a problem. I hear some people laughing. You know that story. I've got Tommy, he's a spendthrift. You give him $5, he's already spent 10. Susie, she's been through bankruptcy 3 times, but when I die, let's just leave him money. That'll help, right? That'll fix the problem. No, it does not fix the problem. There was a study done that I'm trying to think of the numbers. Now I'm not remembering the numbers. Oh, 40,000 to 4 million, that's what it was. How long do you think on average it took them to spend the inheritance? 18 months on average. $4 million gone. People don't change the way they spend because they inherit money. Do we need to protect these people? Oh yeah. Oh yeah. How about addiction? Unfortunately, we have to talk about addiction. Can you imagine leaving money to your addicted child? Can't. So what did we used to do? Oh, we'll give it to Timmy and he'll take care of Susie because Susie can't handle her own money. And then Timmy, God forbid, gets sued or something bad happens to him and he can't provide that money any longer or gets a divorce or any of this stuff. So giving kids money or beneficiaries money doesn't make sense. Disabled or becomes disabled is very simple. Every trust plan we do comes with a standby special needs trust, which means anybody who becomes disabled or is disabled gets a very special thing and they don't lose their governmental benefits. It's a really cool thing. Divorce, I don't know about you, I don't want my ex-son or daughter-in-law getting half of what I left my child. And finally, financial aid. Probably one of the worst ones. Grandma says, oh, Susie, she's going to medical school. I've got to leave her extra money. What does she leave? $80,000. And Susie goes to medical school, Grandma dies, and Susie loses all her financial aid because she now has $80,000, which won't pay for medical school, right? So you see all these things that are affecting what we do in our planning today. We have an answer for all of it, by the way. We can do this. It just takes your doing. It takes your being proactive rather than reactive. Lawsuits, are they a threat to your financial security? I would say yes. Well, I heard they're closing the courts. Nobody's suing anybody anymore, right? No. They're suing more than ever. And so are these potentially a threat to you? Yes. I think number 3, you have to know your options. What is estate planning? It really is who's in control, who gets to benefit, and when. Think about that. I know it's probably a little generic, but let's start there. Because I'm alive and well, so I'm in control. I get to benefit right now. And you see, that, to me, is very easy to answer. But let's muddy the waters. Let's say I have a stroke. I'm alive, but I'm not well. I'm incapacitated. Who's in control? Well, not me. I'm incapacitated, so maybe my power of attorney. And what do? I don't know. I hope I trusted the right person and they're going to do that right. All these fun things, questions. It's harder to answer, but I say don't worry, because the difference is we're here talking about these things, right? We're talking about them. Because when you die, you think, oh, the game's over, right? It's whatever happens, happens. No, see, if you answer these 3 questions now while you're alive and well, it doesn't matter if a spouse becomes incapacitated, remarries, divorce, addictions, right? All these things can be answered by answering these 3 questions. And we're going to help you answer these 3 questions. When I ask people, what do you want out of an estate plan? They basically tell me the same 3 things. Number 1, I want to be in control. I'm not going to take a poll of hands, but who doesn't want to be in control? Number 2, they don't want to be a burden. And number 3, keep it simple. Those are great goals, and we have 3 more for you. You have to know the difference between documents and planning. And through the process, you will see the difference between all of those. And then understand all the costs, because you could have the greatest plan that was ever created in the world. But if you spend every penny you've worked for your entire life, why did you even plan? So we need to talk about and understand those costs. And finally, know the options and choose the plan that's right for you. So we can go through guardianship, probate, administration, or we can do something else. What is that something else? Well, number one is to protect from long-term care costs, because if we cover this topic, we've covered everything else we want to cover. In asset protection, this is your biggest cost, right? I think right now, there are a couple homes that are about $16,000 a month for skilled care. And by the time, hopefully we never need it, but if we do, it's going to be a lot more than that. And so, therefore, we have to plan for it. So I'm going to show you how Medicaid works, because if a crisis occurred, what would happen? Well, Mary Smith, I changed the name to protect the innocent, but a real client, had about $500,000 and was going into a nursing home. And ultimately, her daughter called and said, Matt, I need to know what to do. Well, there are things by law that we can do. The whole point of this slide is it's never too late. Even though Mary was going into the home, we could still help that family protect some of their assets. But let's talk about you and I. Mr. and Mrs. Richards, I call them. They're happy, healthy, and they have about $577,000, and they want to know if they give their assets away, can they protect them any sooner than 5 years? Well, see, Medicaid really works on a penalty system. So yes, they look back 5 years, what did you do? But then they will tell you, okay, within that 5 years, if you give things away, then there'll be a penalty. That penalty is based on a number that comes out every year. And so that right now is $7,787 a month. So every $7,787, thank you Medicaid for a nice round number, they won't pay for 1 month. So in Mr. and Mrs. Richards' case, if they created a plan today, they would start protecting their assets over time. The thing is, we all have our own numbers and our risk of loss, so what I'm going to offer is the ability to get those numbers for you. I don't want you to remember numbers, just know you have your own numbers. But let's get to the meat and bones. How do we do this? How do we protect our stuff? We do it with the right trust. A trust will put you in control rather than anyone else. A trust comes in a couple different flavors. There are only 2 types of trusts in the world, testamentary and living. Testamentary trusts are done in a will and have very little applicability to you and I. So we really don't focus on those. What we focus on is a living trust, and the living trust just means you created it when you're alive, right? That's simple. It doesn't mean much more than that. And there's only 3 parties to a trust. There's the grantor, the person who created the trust, that's you, the beneficiaries who get the stuff, and the trustee who manages the stuff, right? There are a couple different flavors of trust. There's revocable and irrevocable. Revocable I call the can trust. You can be a beneficiary, you can be a trustee, you can, right? All these things you can. Well, why would someone do a trust like that? The first reason is to avoid probate. But remember all those things we talked about, divorce, addiction, that's the other reason we do this. We provide. I always argue that you love your kids way too much to give them money. You love them enough to give them a trust. See, a trust doesn't die, a trust doesn't become disabled, right? So these are the things we need to do in order to protect our beneficiaries. And I signify it as an open box because there are no limitations. But if you want to protect your money, right, then you have to go and look in irrevocable. Well, there's different kinds. I want you to be very careful when you do this, because irrevocable generally means this. That's a closed box. That means you cannot control it. You cannot be a trustee. You cannot. Well, who would do a trust like that? Remember all those people worth $13.9 million? They do it for tax reasons. What we do is an irrevocable grantor trust. And in this trust, what we do is it's a box with a lid. So you get all the cans of the revocable, but only one can out of the irrevocable, and we start protecting assets from creditors and lawsuits day one, and long-term care costs over time, right? We all need 5 years for it to be all safe. So these are interesting things to me, because a trust, what I hear people say is, I don't have enough money for a trust. But you see, a trust is not based on how much you have. A trust is based on your goals. So whatever your goals are determines whether or not a trust even makes sense for you. How do I create my rule book? Remember I said plans work, documents don't. This is a plan. You not only have to create it, you have to integrate it, and you have to maintain it. Without all three, it usually doesn't work. What do I mean? Well, think about it. If I create this trust, or a will, or anything, right? What if I don't integrate my stuff with that plan? Well, then it kind of fails me, right? It doesn't work. For example, I can do transfer, we talked about joint accounts, beneficiary accounts, right? I can do payable on death on my accounts. I can do transfer on death on my stocks. But that doesn't always work. Why? Think about it. Let's say I have 3 beneficiaries and one passes away. Typically, most beneficiary designations, it goes to the other 2 and not the kids of the 3rd one, and it's maybe not something you wanted to happen. See, it's basically you take control. That's the difference. It's you taking control of your assets and making them pass as efficiently as possible to the next generation. Having a rule book is the first step. Remember, we have to integrate it. So if we create a trust, oh, I forgot to say, a trust to me is a little red wagon. It's just a vehicle to put your stuff to ensure who gets it, when, and how. That's the basics of estate planning, right? So that wagon we created, you have to put your stuff in it. You know how many people come in and say, oh, Matt, I've got this trust for my parents and we need to administer it. And I say, well, what's in the trust? Oh, nothing. Oh, well, then we have to take it all and go to probate. Well, wait a minute. I thought a trust avoids probate only for what's in it. Because remember, these joint accounts, beneficiary designations, whatever, they all avoid probate, but they're not part of your plan. See, avoiding probate's not the only thing to worry about anymore, as we can see, right? These are the things we need to consider. Once I create it, am I all set? I always say the thing that is constant in life is change. Change, change, change. So, you have to maintain it. You know, I have people who come in, they've got a trust that are 10, 15, 20 years old. Will it do what they want it to do? Maybe. Maybe. Is it a good time for review? Absolutely, for sure. And in our firm, we do have a maintenance program that is optional. I have about 72% of my clients on maintenance, and they come in every year for a review, and we update documents. It's all included. So, did you hear kind of the basics? Did you hear the story about maybe I'm not all set, that maybe we need to review at this point? And if you don't have anything, maybe start creating it. Do you understand what it takes to protect you and your stuff? If you said yes, I would say you're in the wrong room. Right? It's not that easy, but it's what we're here for. Now, we offer these workshops to all of our clients. However, I will tell you, there are a lot of people who do what I do. And that is great. And you may already have someone. That's awesome. Just make sure you keep it current, that you review it, that it makes sense, that the options you're being offered make sense to you, right? Explore what options are out there for you. Did I cover all these questions? The answer is no, I forgot IRAs. So let me go back to IRAs real quick. When I say IRA, I mean anything that is pre-tax. So that's IRA, 401k, 457s, 403bs, right? All these fun things that you have that you haven't paid tax yet on. I will tell you that I believe when you retire, the best thing you can do is convert them. right? Start taking money out now. Why? Well, God forbid, I hope if you ever need nursing care, you have to liquidate all those assets at once, and you pay a huge amount of tax to do that. Number two is when you pass those IRAs to your kids, they pay at their tax rate. Now, my hope is for my kids to do better than I, and I hope all of your kids are doing better than you, or your beneficiaries, whoever, but then they pay at a higher tax rate. So it's ultimately a question for you and your tax preparer, but it's just something I like to mention because I think it's worth mentioning. I think it's something everybody should consider once, because once you retire, your income goes down, right? And that's the time to start converting, is usually when it makes sense. Good. Did I keep my promises? Did this go quickly? Did you learn something? Did you have some fun? I hope you did. I hope I made you laugh at least once, because there should be fun in everything, in my opinion. If I did, I'd ask you to just fill out that evaluation for me. And if anyone is interested in working with me, you have to act, right? It's proactive estate planning. You have to assess your needs, create what's missing, and tie it in with your plan. What we do is a vision meeting, and in a vision meeting, we'll focus on you and your stuff to ensure that you're going to have the ease of transfer and the best possible outcome when you're gone. Thank you. I know everybody has a lot to do, so I appreciate you just taking the time out of your day to listen to me. And I know I don't even know what time we're at, but now it's time for some questions. So, questions, yes? I'm sorry, say that again?
Do you accept the MetLife legal plan?
So the question is, do I accept the MetLife legal plan? So I am not part of that. No, if you have, is that something that's offered through your employment? Take advantage of it. It's awesome, right? Just explore and make sure you're doing more than just the basics, right? What is offered? If you're doing a trust, you need to know the difference between revocable and irrevocable. In a lot of those plans, some of these plans are not offered, right? Like an irrevocable grantor trust to protect your assets are probably not going to be offered to you in that plan, but absolutely you should be exploring that and getting at least the basics in place for sure. Absolutely. Yeah. I'm just here to hopefully give you the information. Other questions, concerns? Yes?
I wanted to know how affordable is it to set up a trust?
How affordable is it to set up a trust? It's a great question because and I'm not sure if the MetLife legal plans do trusts or not. They might just do wills. I don't know. You'd have to, if you know that, tell me or follow up with me. But a trust, you're going to be a couple $1,000s to be in a trust, to be honest with you. It's not inexpensive planning, but don't forget it's one time, right? If you go through probate versus not going through probate, the costs are astronomically different, right? So it's all a matter of, to me, it's not just about what you're going to pay for your plan. What are you going to pay when you're gone? What will your beneficiaries pay? That's a huge deal to ask, right? And so we can talk about that in general too. So thank you for that. Thank you. Yeah. Anyone else? Yes, sir.
You said earlier, a couple $1,000s for a trust. Mm-hmm. Then you mentioned earlier that you have a maintenance plan. Is that included in this?
Very good. So with us, I can only speak for me, right? I don't know about other firms. But in general, our maintenance plan is optional, but it is included in the plan you obtain from us for the remainder of the year. It's usually at some point during the year we extend it, so you get as close to 12 months included as possible. If you're not on maintenance with me, then you just come in and you make a change and you pay at that time. Otherwise, people who have trust with me, it's $495 a year for maintenance, and that includes a lot of different things actually. It includes unlimited access, it includes maintenance reviews, it includes educational events. We actually have some social events, so it includes a lot, but it's optional. So yes, you get it for a year, and then you decide.
So going back to the $2,000 for another question, is it is the $2,000 kind of based on the amount of assets you're attempting to put in?
Yeah, is the cost based on your assets? No, not at all. It's based on the amount of work we have to do for you. So remember, we talked about plans being creating it, integrating it, and maintaining it. Integrating it's important, so you have to make sure that your assets are in that trust. How do we do that? Well, we make sure that we give you a list and homework of all the things you need to do to ensure that all of your assets end up in that trust. So you have some homework to do when you do this, believe it or not, but ultimately, it works in the end. For example, I had a woman come in, her husband passed away. She had a trust and everything was funded in it. So we had to do an affidavit saying he's no longer trustee, just she is, and we were done. You know, the wife didn't have to go to the bank and change the accounts and go change the house and all that fun stuff. So again, the ease of transfer. But yes, no, the cost is not based on what you have. Good. Other questions? Yes.
First question is, how long does it take typically once you have all the information from your client to actually create the trust and have it actually active?
So how long does it take once we get the information to do this? We go as fast as you want to go. I don't like 2 weeks between an appointment because then you forget, I forget, right? We want to make sure that it is rolling. So when we set up a trust, you would probably say in the quickest form, probably, I don't know, 3 to 4 weeks, and then you have to fund, right? So you have to get that stuff in the trust. So it doesn't just end when you sign your document. You can't just sign documents and leave. You got to fund it. So funding could take you a month. It could take you 6 months. I've got someone, I saw, we were at the Cleveland FOP, and one of my clients was there, and he goes, yeah, I'm not fully funded yet. I'm like, we did this a year ago, you need to come in, right? That's what maintenance is for. Maintenance helps you get those done. So I hope that answers that. Yes.
And it triggered.
Another question. Yes.
So funding just means making sure that all your assets are in that.
That's correct. So funding, just to repeat that for the camera, I'm repeating hopefully everything. I hope I didn't miss anything. But yes, funding is actually putting assets into the name of the trust or beneficiary trust. And that's what we'll go through together, because I'll give you an example. If you put your car into a revocable trust, you have to typically get new stickers and plates. Well, who wants to do that? So we just add beneficiary to the car to the trust, for example. So every asset's a little different, and we'll deal with every asset that you have.
Is it common to have both trusts?
Is it common to have both trusts? Yes and no. It really depends on your goals and what you want to do. You can, absolutely. A lot of my clients have both, but a lot of times they'll do one or the other, and then just make sure everything's beneficiary to the trust. But yeah, we can talk more detail on that one-on-one if that's okay.
So,
Yes, thank you.
I'm keying off what you said earlier, using the car as an example. You got to get new tags for a car. So are you transferring your assets from the individual to the trust? Is that what's happening?
So the question is, with the car example, right, are we transferring our assets to the trust? It just depends on the asset, but yes, you can. In an asset protection trust, you have to transfer in order to get that protection. So yes, the ownership of the asset will change from you to your trust. But don't forget, I don't care about who owns it. I care about who controls it. You have to be in control. If you're offered any plan in which you have to give up control, that's no longer necessary, and you don't have to do that. Does that make sense? Good. Excellent. Yes? Oh, sorry. I didn't see you over there. I got to keep looking around. I'm sorry. Yes? Uh-huh.
And also a business, several businesses. Can you put it in your trust where it's that you still control over it? However, can you put it in the trust where you can dictate how you want the houses to go to?
Ah, very good. I think I understand. So we're talking about houses, businesses. So, okay, I put this stuff in the trust. Now what happens? Do I dictate in the trust where it goes? The answer is yes, because think about it. If I have beneficiary on this account, beneficiary on my IRA, and this designated and this, then when I have a change, I have to change all those things. If I put it all in the trust, all I have to do is change the trust to make all those changes on all those accounts. So yes, you stay in control, but you will also decide where it goes, how it goes, when it goes. For example, one of the biggest things that happens to a lot of families is if they pass, their kids aren't 18. Well, at 18, they get the money. In a trust, you can raise that age. We want to make it 25 as a minimum in my book. I always say at 18 we buy a Corvette, and at 21 we buy beer in a Corvette, right? We don't want 18-year-olds in control of money. So a trust will enable you to do that as well. Good. There was another, I'm going to go here and then you. Yes?
Is the trust document recorded with probate court or
A trust is a private agreement that is not recorded anywhere. It is between you and your beneficiaries. Absolutely. Great question. Yes?
I have a question based on her question.
Uh-huh.
Having a trust, and if you did a transfer upon death, if that's already designated, then you wouldn't necessarily need a trust for that. Is that correct?
So you just used a word that makes me go, oh, every time I hear it, and that's transfer on death. Whether you say deed or affidavit, because we started calling it a deed, now it's an affidavit. If you have one beneficiary, a transfer on death affidavit works. If you have multiple beneficiaries, I don't believe it works. And I'll tell you why. And so it is an alternate, right, to avoid probate and to pass the asset, right? But I had a woman who had 6 kids. She could have had 2 kids, it didn't matter, because only one was getting a divorce. And in Ohio, we have the thing called dower rights. So I can't sell my property unless my spouse signs off, right? They have to acknowledge that, yes, I'm transferring this property. So the one getting the divorce, the ex said, well, I'm not signing anything. Well, they held up the sale of that house for 3 years. And you imagine taxes, insurance, right? All the fun things that go along with it, and the legal fees to get that house sold. They lost a lot of money. So I'm very wary on transfer on death. Like I said, if you have one beneficiary, that works, right? But if you have multiples, I don't like them.
Okay.
Does that answer it?
Yes.
Good. Yes?
I've heard where some people have children.
Uh-huh.
You may have one that says, no, I don't care what you do with everything, just give me my part. And obviously to give them their part, you would have to sell it. So I guess how does that work?
So
You have a child that's married and then it's an issue with this spouse.
Yeah, so I think I understand it. If I answer this wrong, tell me. With children, right? Some might say, I have kids who come in and they say, I don't care if mom and dad leave me nothing, I'm doing fine, I don't need it, right? You have others that say, just give me my share and that's it, right? So you designate them as beneficiaries, right? And then they get it. Well, it just so happens my daughter was in a bankruptcy. She doesn't get it. It just so happens that my son was getting sued. He doesn't get it, right? Like, the whole point of me saying that is that you want to pass it in trust rather than pass them the money. But you can pass them the money and say, look, whatever happens, happens, right? That's up to them. But maybe I didn't understand quite what you're asking.
You may, let's say you own a home,
Uh-huh.
and you'd like at least one of your children to maintain or have that home.
Okay.
The other spouse, or not spouse, I'm sorry.
The other kids.
Child says, you know what, you can, but give me my money. If you can't give them the
Oh, I got you. So one kid wants the house, the others want their money. So typically, let's say I have 3 kids, so each one's entitled to a third, typically, unless I leave specifically the house to one, which you could do. And you could do that in addition to their share, or you can say, no, that's, you know, part of your 1/3. I leave you the house. You can do that in a trust. And so let's say you leave it to all three and one wants it, then they have to agree on a price and the other two have to get compensated for the third, whether that's from the child or from the trust or the estate, right? Then that's kind of how it's done. There's no great answer to that. But if you know for sure that you want one kid to get that house and your house is worth $200,000 and you have another $400,000 in the bank, I'm just trying to make it $600,000 to make it divisible by 3, then they would get 200, they would get 200, and they would get the house, for example. Or you could say, no, I want to give you the house, and then you still get a third of everything else. It's really up to you. And so you can do all that in a trust. You can't necessarily do that all in a will. So you want to look at who you want to leave it to and why and how, and we can answer all those questions for sure. Great. You had a question? I'm sorry, I can't. What is a pour-over will? Yeah, a pour-over will is a backup plan to your trust. So what it is the beneficiaries of your will are your trust. That's a pour-over will, which means to say, oops, I forgot to put something in my trust, so therefore it's going to go through probate, but go to the trust. That's a pour-over will. So when you have a trust, you also have a will. I'm sorry. Yeah, so anything you don't fund in the trust while you're alive will go through probate court, sure. If it's in your name only, right? Yes?
And how do these relate to debt?
To debts. Awesome. How does this all relate to debts? In Ohio, the law says that creditors have a right to make a claim against the estate for 6 months after the date of death. After 6 months, they're barred. But creditors in Ohio are only subject to what's in probate. So if you create a trust and fund it 100%, then those creditors are not able to touch what's in your... Now, okay, I say that, but the house mortgage always goes with the house, right? You can't, that's not something that, but like unsecured medical, credit cards, those kind of things, yeah. Sir, you had a question?
I understand healthcare is the big unknown, and in my mind, that's why you get a trust to protect your assets. But let's say just normal, 2 beneficiaries, adults, and pretty sure we're not going to have divorce, et cetera, et cetera. That could happen. But a will, transfer on death, all the stocks, all the 401k, the firm comp, the split between the beneficiaries, if that's all in writing, unless something crazy happens, which you understand, that should be as good as a trust. Not as good.
Well,
You know what I'm saying?
yeah. So just so I repeat it for the camera, I'm going to paraphrase real quick, but essentially if I have beneficiaries on everything, if I've set up everything correctly, do I really need a trust, right? Is that ultimately what it comes down to? And I would say no, unless you know where your kids will be when you die, right? So for example, let's say, God forbid, I do have a child going through bankruptcy. Well, I can leave them beneficiary and they'll go right to the bankruptcy, right? So that's up to you. Those are the chances we take. Here's what can happen. Do you want to protect against it not happening, right? That's ultimately where it comes down to. Yeah. Any others? Yes, sir.
In terms of building a trust strategy around Medicaid, what age do you recommend?
These are all great questions. I really appreciate you guys coming out because these are great questions. So what age would you start planning to protect your assets, right? I always ask people then, how old are you? Now, right now. It depends on what you have. It really does. Because let's say I have a client that has 90% of what they have is in an IRA or 401k, 403b, 457, right? All those things, deferred comp, all those things, right? Those assets can't go into a protection trust because then you pay all the tax. So in that case, I'd say no matter what age, I wouldn't do it. So it's all a matter of, in this vision meeting that we do, to me it's a no cost, no obligation, just come in and talk about it. So we take all this information and bring it down to you, and then we can say, well, yeah, that would absolutely make sense to start it now, or no, that wouldn't work for you. Does that make sense? So it's individual. I have people in their 30s who own businesses who absolutely should have an asset protection trust. Why? They employ 50 people, God forbid they're in a car accident, something happens, whatever, right? We know the business will continue, for example, right? So that's one example, but out of probably many. Very good. Yes, sir.
So I may have missed that.
Huh?
So does the trust, for lack of a better word, shield you should you need Medicaid? I get confused about
It can, depending on the type. It could, but it depends on the type of trust. And I hate to keep saying it, but really it's all about, let me just spend an hour with you and figure out if it even makes sense and how it works. Does that make sense?
Yep.
Because it's all dependent on your assets. Like I said, 90% in IRA doesn't work, but certainly, you know, everybody, not everybody, but if you have a home, that could be one of your largest assets. You know, is that something you want to protect? It's really personal. It's up to you. Yeah. Good. Excellent. Others? Wow, this was fantastic. I want to thank you for your time today, and we're located in Independence, just so you're aware, so we're on 77 and 480. Again, you have multiple options. I just want you to be educated, to know the options, to know what you have. Because, for example, the biggest thing I see today is a power of attorney that's dated a year ago and doesn't have the powers you need to protect your stuff. Well, that fails you. So we got to make sure everything's up to date and current and makes sense for you. Thank you. And I hope you have a great day. Thank you.